Over the next couple of weeks, we're going to talk about agency. In part one of chapter 17, we're going to talk primarily about the formation of agency relationships, uh, things like the difference between employees and independent contractors and whether they're agents or not, as well as the duties of both the agent and principal. An agency relationship includes a principal, an agent, and a third party. Basically, an agent is somebody who represents a principal to third parties. It's important to understand how agencies work because a lot of businesses do business in multiple locations at the same time through agency. The principal has the right to control the agent in matters entrusted to the agent, and the agent has a fiduciary duty to the principal. You want an agent to be someone that you can really trust because they're acting as if they're you. You can have agents in employer-employee relationships, but not all employees are agents. Employees who are authorized to deal with third parties on behalf of the principal are agents. The key to determining whether somebody is an employee is control over their work, and there is an exhibit in your chapter that kind of goes over the factors that a court would look at in determining whether somebody is an employee versus an independent contractor, and also what's within the scope of employment. Somebody who employs an independent contractor has no control over the details of how they do their work. That's primarily the criteria that's used by the IRS. Somebody could be hired as an employee to do work, or they could be hired as an independent contractor to do work for hire. Typically, if somebody is hired to do a job for an employer, the intellectual property belongs to the employer. One thing you want to do is make sure that's clear in any contract to hire an independent contractor, or even in the case of an employment contract. Agency relationships are consensual. They don't require consideration. This makes them a little different than a contract. You can have agency by contract, but you also could have an agreement to represent somebody without paying them to do it. Notice that the principal in the agency relationship is required to have contractual capacity. The agent is not. An agency can be created for any legal purpose. Many agencies are formed by agreement, either oral or written, or they could also be implied by the conduct of the parties. In other words, if the actions of the parties, principal and agent, indicate that there is an agency, then it will be implied. There's also agency by ratification, which is basically agency after the fact. So somebody who is not an agent or not authorized to act as an agent as to certain matters does act, and the principal finds out about it later, and they ratify that act or agreement. There is an agency created after the fact. It's also agency by estoppel. This occurs when the principal makes the third party believe that the agent has authority they don't have, or that somebody who is an agent who really isn't. And the third party acts in reliance or detriment to the principal's actions, and this is reasonable. You can also have an agency that's created by the law, or agency by operation of law. We mentioned minors in contracts for necessaries. So in some cases the law implies there's an agency when there isn't one. It's kind of like thinking about implied in law contracts. This is implied in law agency. Agent's duties owed to the principal: one of performance, in other words, to do what the agent was hired to do. It's implied that an agent will act with reasonable diligence and skill. If they don't, then that would be potentially a breach of contract if there is a contract. And then a gratuitous agency, in other words, the agent doing something for nothing they would only be liable for torts that they commit. There's an agent's requirement to notify the principal of all matters concerning the agency. A duty of the agent to act for the principal, not in their own interest or the interest of a third party. This is really a fiduciary duty, and may have heard of it as conflict of interest, acting for oneself instead of who you're supposed to be acting for. And obedience, to do what the principal says, as well as accounting. If an agent gets money that belongs to the principal, it's held in trust or delivered to the principal. Principal owes duties to the agent, a duty to compensate, either if that's either part of some express or implied agreement, to reimburse them for expenses that they incur on behalf of the principal. Indemnify would be if an agent is sued, that the agent would be able to turn around and seek indemnification from liability from the principal. A principal has a duty to cooperate with the agent as to matters related to the agency and provide safe working conditions.